Hi, my name is Lyle Block-Collins. I am a business and new media lawyer here at McMaster Innovation Park. Today I'm going to be providing an overview of shareholder agreements, including what they are, when they're needed, and some of the essential elements you'll find in them. A shareholders agreement is essentially a contract or an agreement amongst the shareholders of a corporation setting out the rules by which the corporation will be managed and operated. For a closely held corporation, a shareholders agreement is typically recommended anytime there's more than one shareholder. However, many successful companies are run without them. There typically is not a standard form shareholders agreement that a business can use, although it may be advisable to look at existing shareholder agreements which can be found on the internet or perhaps through a friend or business associate to gain a little bit of knowledge about how a shareholders agreement operates and what it looks like. Each shareholders agreement is supposed to be customized to each individual fact pattern and set of needs. Each business has unique needs and it's totally dependent upon the individual participants and the nature of the business. So no, it's typically not possible to use a standard form agreement. Although a shareholders agreement is gonna deal with a whole range of issues, some of the essential items that the shareholders agreement is going to want to highlight are decision making, money matters, and exiting the business. So I'll deal with each one in turn. With regard to decision making, you want to outline who's going to be making what decisions. Do certain decisions require unanimous consent of all the shareholders? Only a majority? Are certain shareholders charged with making decisions on certain subject matter and not others? So that's something that you want to outline in the shareholders agreement. The second deals with money. Money in. Who's investing what in the corporation? You want to keep track of who has invested what and what type of shares they've gotten for that contribution. You also want to deal with a situation where the business requires more capital. Are the shareholders required to contribute that capital? Are they required to get a bank loan? Is each shareholder required to contribute a certain amount? Perhaps some more than others, pro-rata by their share ownership, and so on. Dealing with pulling money out of the business, which is obviously an important topic. Are some shareholders going to be pulling out money differently than others? When are dividends going to be paid? These are decisions that should be addressed. Now, on a more morbid topic, the shareholders agreement should address the issue of death and disability. What happens if one of the shareholders dies during the currency of the relationship? Is the corporation required to pay to buy back those shares? Is the other shareholder going to be buying those shares? Here we have estates planning issues as well as tax considerations to be made. So this is why professionals are recommended to be involved in these decisions. It's typically recommended that a business establish a shareholders agreement earlier rather than later. It's much easier to agree when everyone is still friendly and on good terms, and that's typically when the business is formed. Keeping in mind that this agreement is essentially an insurance policy against costly litigation down the road, it obviously makes more sense to forecast and enumerate those issues before they've arisen.